have outlined. One is that federalism is a basic feature of the Constitution. No, my lords, when your lordships have said that, the federalism, my lord, that is revealed, my lord, from the reading of the Constitution as a whole. My lord, please keep 370 for a moment aside. Is, my lord, where the distribution of the legislative powers with the Parliament and the state legislatures, and with the slanting, my lord, in favor of the state. The reasons have all been given, my lord. I need not repeat it myself because your lordships have articulated it so well, my lord, in the earlier judgments. Now, my lords, whatever it is, your lordships will find that 370 constituted when your lordships have a holistic picture of the Constitution and the relationship between the Union and all the other states. And then if your lordships looked at 370, my lord, put in an area or carved out an area, my lord, which is not in sync with the general federal features of the Constitution for the rest of the country, for the Union and the rest of the country. Dr. Dhawan, my lord, pointed out other features, my lord, in part 21, 371 onwards. Point is, my lord, over a period of about 25 years, different provisions were introduced, were inserted in the Constitution, giving a certain special provisions, my lord, for some of the states, and all, therefore, an amendment of the Constitution and the parliamentary legislation. But point is, my lord, there are 2 or 3 features which emanate out of 370. One is that Parliament requires the consent of the state, the government of the state in relation to matters which are included in list 1 and 3, but not relatable to the instrument of accession. That the consent of the state is required for making applicable certain all provisions of the Constitution which have been mentioned in clause D.
Just one second. As the consent of the government of the state on list 1 and 3 matters.
Yes.
Which matters do not relate to the IOA. That's
yes.
Right. Yes.
No, my lord, sin.
That is B2.
Yes, B2. D deals with such of the other provisions of the Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. And then the second proviso, concurrence of the government is necessary. That it has been done repeatedly, my lord, from 1950 onwards is a historical fact. But the point is, my lord, this sets out the relationship between Union and Jammu and Kashmir at a plane. I'm not saying higher or lower, I'm saying at a plane different from the constantly interworking relationship between the Union and all other states in the country, all other states forming part of the Union. My lord, when 370 is abrogated, you have a situation, my lord, which is, my lord, please consider the bifurcation of the state into 2 union territories, my lord, differently. That came about on 31/10/2019. I'm saying, my lord, that when 370 was abrogated by 272, and, my lord, all the provisions of the Constitution became eo instanti applicable to the state of Jammu and Kashmir. Jammu and Kashmir, therefore, became a state, my lord, on a complete par with all other states, my lord, in the Union insofar as the federal structure is concerned. Even other parts. Now, my lord, what do the petitioners want? As a solicitor, my lord, it's pains to point out there is a great deal of expansion of rights, my lord, which could be enforced by the persons who reside in the state. But, my lord, what do the petitioners want? They want the 272 and 273 to be set aside and Article 370 to be resurrected. If 370 is resurrected, we would come back to a stage where there is an oddity insofar as the federal structure of the constitution is concerned. J and K would continue to be placed or would once again be placed on a plane different from all the other states of the union. And the federal working relationship which the constitution behoves us to do will meet with a roadblock one way or the other. Lord, I'm not saying that the one principle of administrative law which your lordships have always applied is your lordships would not issue a prerogative writ in setting aside any order or setting aside any action taken by the executive. My lord, if such interference by your lordships resurrects, my lord, a situation that was also not completely legal. My lord, paraphrase it. If setting aside 272 and 273 resurrects Article 370, in my respectful submission, if Article 370 is resurrected, that would also be violative of the basic structure of the Constitution. Yes.
This might be a little too far-fetched because then that would be to postulate that original Article 370 was violative of the
There was a challenge. There was a challenge pending here for several years. 1986, my lord, a batch of writ petitions was then made over to the High Court, whether that's still pending. There are people, my lord, who wanted to prosecute it. But of course, my lord, one of the writ petitions challenging 35A is also, my lord,
It was a part of the original constitution, Mr.
I'm saying, my lord, that the federal structure, my lord, I would only, my lord, let me go by the path of least resistance.
You can't invite us to hold in your favor on an unstateable proposition.
No, I'm saying, my lord, that your lordship, let me take the path of least resistance. My lord, the federal structure which emanates, my lord, from 370 is on a different plane from the federal structure.
Mr. Giri, you are not today confronted with a situation where Article 370 is in the Constitution.
I'm saying, my lord, that if there is a resurrection, then, my lord, there is still, my lord, a cause of action.
35A, etc. is on a different.
I understand, my lord. I'm saying, my lord, these.
I think we better wrap up.
I am wrapping up.
11:25.
My lord, just one aspect on which your lordships wanted an answer, my lord. In Madhav Rao Sidhya, my lord, 1971, 1 SEC 85. Volume 6, PDF 390. My lord, I'll just give the page number, relevant PDF page numbers and paragraphs. My lord, Chief Justice Hidayatullah's opinion, para 65, PDF 443.
What
Para 76, PDF 447.
volume?
My lord, volume 6, my lord, of the case law compilation.
Yes.
Decision starts at PDF page 390.
So what is the proposition you're citing it?
My lord, it's only this, my lord. Your lordship, the solicitor had taken your lordship extensively through Ganpat Rao,
Yes, yes.
which came about later. My lord, the mandamus was issued in Madhav Rao Sidhya, my lord, where after a serious bit of ratiocination, the lordships came to the conclusion, both Chief Justice Hidayatullah and Justice Shah, that the right which is claimed by the petitioners emanates from Article 291, Constitution, and 362, and not from the covenant. And this is same conclusion was arrived at to hold that 363, which is a bar on the courts not entertaining such disputes, is not attractive because the right claimed by the petitioners is on a right which is generated and frameworked in the Constitution and not in the covenant. That is why a mandamus is issued. We don't have a parallel
One
here.
second. You said that the rights, but Justice Hidayatullah and Justice Shah said that the rights which were claimed by the petitioners originated in Articles 291 and
362,
and not in the covenant.
not from the covenant.
And what is the next? What is the sequitur that?
And therefore, my lords, that 363 was not attractive. 363 has been subsequently repealed, but 363 was not retracted, and therefore a mandamus was issued. Therefore, my lord, the right claimed by the petitioners was under the Constitution itself. 291 and 362 were repealed. Earlier, my lord, it was only a question of, my lord, withdrawing the recognition of a ruler under 366(22). That was found to be inadequate because 291 and 362 were still intact. That is why, my lord, in the first matter, in Madhavrao Sindhya's matter, a mandamus was issued.